I stood up to 4 New York State troopers and to a judge and a clerk about a RICO, a racketeer influence crime organization proceeding that's going on not only in this town court, but I think, well, I've seen it in many town courts, so it must be universal. And it's this vehicle and traffic racket and this New York State tax and fees and registration and compulsory insurance, and I am taking a stand against it. I will be reading this paper to you very, very shortly. This is summertime, and it's the time of year when Americans put aside the Rubik's Cube and undertake the ultimate challenge of all time, refolding a road map. Folks, here's something I want to share with you. I just, with great exertion, got the address of Comcast in Springfield. I told you that. And I got these all ready to go to the mailbox for the 11 o'clock pickup. And guess what I find? Guess what I find? Yep. So, let's sing a song together. Soft as the voice of an angel, breathing a lesson unheard, hope with a gentle persuasion, with her comforting word. Wait till the darkness is over. Wait till the tempest is past. Hope for the sunshine tomorrow. After the shower is gone, whispering hope. Oh, how welcome thy voices, making my heart in its sorrow rejoice. Rejoice, rejoice, rejoice. If it isn't over by 11 or 11:30, I'm going out and get drenching wet. Justice cannot be adjourned. So now I'll get dressed up and videotape it for you. I never like to go in front of you without being dressed up. Keep America beautiful. Well, folks, on a rainy day, who dares to attack the money changers? Who dares to stand up to these RICO, the vehicle and traffic RICO that goes on in every court, I guess, in the United States. Well, how do I know? But I've seen it go on in several. And here it is, so-called Justice Court The town of Taconic. You see how that's spelled? I think I spelled it wrong. County of Columbia, State of New York, United States of America, because of the internet viewers. And it's the people of the state of New York, whatever that means. Totally meaningless. Plaintiff versus Glendora defendant. And here are the... There is no index number, but here are the tickets. It's a Lulu. It's a Lulu. It was a great day for Trooper Peter J. Andrews. 3 socks. But I'm telling you that I really was interested in how vigilant the state police force was, how long it would take them to catch unlicensed, unregistered, and seatbelt. And it took them a long time, 1.5 years, I believe. And furthermore, the Department of Motor Vehicles is wrong not to accept the post office address. They insist upon a street address. Alright, so you give them a street address. And then you move. And they send out the registration papers to the street address, and there's nobody there. And it's returned to them. Now what do? They should accept the post office box. Here we go. This is a notice of motion, a motion and an affirmation in support, together with notice to this court that for purposes of appeal, Glendora takes exception to everything that happened in court 8:05 p.m. to 8:25 p.m. on June the 22nd, 2006, the first day of summer, or the second, and states that she did not and does not understand what happened therein, together with 1. A motion in writing of the bench motion that this case be dismissed on the grounds it violates her speedy trial rights. Speedy trial is 70 days you go to trial. It has been 110 days and more. 120. 2. Motion that this case be dismissed on the grounds that Trooper Peter J. Andrews did not respond to Glendora's interrogatories. Glendora's 11 interrogatories. And 3, motion that Judge William H. Young recuse for never reading Glendora's motion to dismiss of March the 7th. He had 110 days to read it, and I get to court and he's never read it. And that motion of March the 7th said that this case be dismissed on the grounds that Glendora is protected by the common law. And the common law mandates that Peter J. Andrews produce a corpus delicti, an injured body, and he cannot do so. Glendora further incorporates the said March 7th herein, as if fully stated again herein, all 15 pages thereof. The movant is Glendora. The return date is July the 6th, 2006. The location is the Justice Court, the town of Taconic, 909 Route 82, Ancram, New York, 12502. If I were you, I would travel Route 82. I would not travel to Taconic because it's a RICO trap. Relief requested is stated in the title, and the legal bases are stated in the title, and the grounds are stated in the title. And the supporting papers are the contents of this file, Glendora's March the 7th motion, her 11 interrogatories, and the affirmation in support affixed here too. Service of these 36 pages was by U.S. first-class mail upon this court and upon Trooper Andrews at 2541 Route. No, Mosquito, you're not invited. No. Excuse me, folks. Mosquito bites are bad. I have a bump on my hand that came from mosquito bites. Excuse me. What were we saying before we were bitten by the Rico and bitten by a mosquito? These 36 pages that they were served upon Trooper Andrews at 2541 Route 44, Salt Point, New York, 12576, his designated address. Why do they call it Salt Point? June the 26th, 2006, Anno Domini, the year of our Lord, County of Columbia, State of New York, yours in truth, in amor patriae, love of one's country, and in amor New Yorki, love of New York State. And you notice that here's the protection by the common law that's so important. Without prejudice, Uniform Commercial Code, Article 1, Section 207, Glendora. Chatwick, Glendora on 52 TV stations, 520 municipalities, including Albany, New York, and Washington, D.C. And my platform is lead people to be perfect, stop the injustice in the courts, stop the cruelty to animals, and sue judges when they break the law. Now, we add to this that reply papers, if any, must be postmarked on or before July the 1st, 2006. That's Saturday of this week. It's Monday today. Shortness of time is not Glendora's burden. The court and the plaintiff set the date of July the 6th, 2006 with no consultation with Glendora. This case should have been dismissed instantly the night of June the 22nd, 2006. It should have been dismissed instantly. And now, here is the affirmation in support. Alpha, for purposes of appeal, Glendora takes exception to everything that happened June the 22nd, 2006 in the court, 8 p.m. to 8:25 p.m. when her case was called. She takes exception to Trooper Andrews' proffering of a plea bargain. He asked Glendora's Christian partner who accompanied her to court, "Do you represent her?" Meaning Glendora. Amused, Glendora's Christian partner said no. With exuberant cheer, Glendora greeted Trooper Andrews just as she had on the Taconic Parkway 3.5 months ago. "Oh, hi, how are you?" And grumpily, Trooper Andrews, just like 3.5 months ago, responded. Said he, "Do you want to discuss this before trial?" You know how that translates? Mosquito juice. It translates into, "Do you want a plea bargain?" Now, on second thought, I should have listened to him. But I am adamantly, obdurately opposed unconditionally to plea bargaining. It has been one of the things that has ruined the courts. Glendora said, "You mean plea bargain?" "No, I am very strongly against plea bargaining." And Trooper Andrews receded. Plea bargaining is a corruption of justice, a cheat, and a depravity of court process. But Glendora should have listened to him anyway. Everybody else went to the rail. Nearly contiguous to the bench, and approximately 30 defendants I watched go to the rail and pay money. I was the only one to leave that court and not pay any money. Excuse me. Glendora was directed to go to the table and the chairs. Trooper Andrews had seated himself at the table to the right for 20 minutes before. He was writing, and he used the court's copy machine after having problems with it, and the clerk, Mrs. Coffey, telling him how to operate it. Another trooper sat with Trooper Andrews. Glendora takes exception to that. She was not introduced to him, nor was his role explained to her, nor did he make an appearance. Glendora's Christian partner came to the table with Glendora. Mrs. Coffey made the Christian partner recede to the gallery, and Glendora protested. Now, if Trooper Andrews could have a partner at his table, why could Glendora not have her partner at Glendora's table? Don't you think, folks? Further, Trooper Conley blocked Glendora's view of Trooper Andrews, and it is vital to watch the body language of one's accuser. Not clerk, judge, Conley, Andrews said anything else. There was silence, and Glendora said, application to the court. She said she had made a motion to dismiss this case on the grounds that she was protected by the common law, and the common law mandated that the plaintiff produce a corpus delicti, an injured body, and Trooper Andrews had not and could not produce an injured body. The judge instantly began to shuffle through the file jacket looking for the motion. I was aghast. 110 days had gone by and this judge had not read that motion. It was easily recognized by its bright yellow front page. Glendora proffered the court another copy and then withdrew the same as it was not needed, and she offered one to Conley, and he said he could look at Andrews. Gamma. There was silence longer than a minute again, so Glendora said, application to the court. Glendora moves that this case be dismissed on the grounds that her speedy trial rights have been violated. Speedy trial is 70 days, and it has already been 110 days. And Andrews grumbled something about speedy trial did not apply in vehicle and traffic matters. And Glendora demanded that the law, saying so, be produced. I request Trooper Andrews produce his statutory authority on the same. And Trooper Andrews also mumbled something about that was how long it took to schedule everybody in one place. Delta, and we were on page 7 out of 32. There was silence again, and Glendora said, application to the court. She said she moved to dismiss the case on the grounds that Trooper Andrews did not respond to her interrogatories. Now you see, that case should have been dismissed right then and there. It was rank violation of rights, both state and federal. Both Andrews and Conley grumbled that interrogatories were not allowed in vehicle and traffic cases. Well, this is absurd. This is a criminal case, and discovery is a law, and even discovery is allowed in small claims cases. Glendora said, again, I want to see your statutory authority on that. Again, the third time, there was silence. There was no reply to demand for statutory authority. Epsilon. Insert. James Kleinbaum, a lawyer, was there. He affluently fraternized with the troopers, entertaining them with raconteur and evoking hearty laughter. He appeared for a couple of clients and got his dismissals, but did not leave. Glendora sought him out, shook his hand. Even though he's a sleaze, he's sort of likable. And after his appearance, James lingered and waited, and I want to know why. Do you know why, folks? Also, the other troopers, having completed their business with the court, lingered and watched 2 other ones, so that there were 4 state troopers there. Why? And who is paying for their time? Glendora severely beat Kleinbaum's scam with Nasty Natalia, a landlord, in 2004-2005. You remember that. It was reported to you verbatim. They fabricated a $2,500 scam against Glendora in Chatham Village Court, depraved George Dixon and accomplice his wife, the clerk, Joanne Dixon. Glendora sued Natalia. Dixon dismissed in 5 minutes, and Glendora appealed both cases in the Supreme Court, County of Columbia, State of New York. Kleinbaum utterly failed at briefs. He doesn't know how to do an appeal. And during the litigation, Glendora sued Natalia Dixon, his wife, Mrs. Dixon, the village of Chatham, and Kleinbaum for civil rights, state actors, in Title 42 U.S. Code, Section 1983 Civil Rights and 1985 Conspiracy, and the suit was brought in federal court in Chicago. And Chatham hired a lawyer in Indiana. Supreme Court, Columbia County, gave up on Dixon, who did not know how to write an order, nor a return, and turned the case over to Barry Sachs in Hudson City Court. Well, it did not take Barry Sachs long to violate a cascade of civil rights, and the procedure was fatally defective, and Sachs set the trial date in a few weeks, and on that date, Sachs did not appear. I wrote a post-appearance memorandum elucidating the civil rights that Barry Sachs had violated. And Judge Serifia sent Matthew Turner down from Troy at the last minute to substitute for Sachs. The court was delayed 30 minutes. Kleinbaum and Natalia withdrew their case against Glendora, and Glendora invited them all out to lunch, including the judge. Natalia did come to lunch in the next day or two, and we kissed and made up, and Glendora thought about continuing her case against Natalia in Hudson City Court, but finally eschewed. Glendora sent copies of all her papers to Administrative Judge Serifia, the 3rd Department, to Primadora, the Deputy Judge in charge of the administration of New York courts outside of New York County, Jonathan Lippman, the Chief Judge of New York courts. Well, I shouldn't say that. Chief Judge is Judith Kay, but he is the Chief Judge in charge of the administration of New York courts. And I reported it on TV to you and on the internet. And Glendora will not go to Chatham again because of crooked George Dixon, just as she will never travel the Taconic again because of Andrews. And others take care of her TV show in Chatham and in Ghent, Hillsdale, Copiague, et al. Now, did Kleinbaum, on his weird stay over, impart to the 4 state troopers, the judge and the clerk, the chronology that I just gave to you, Super? Did he, folks? Do you think so? We're at page 10, end of the insert, and we're up to topic Zeta. And the judge, William H. Young, was reading the motion as to the common law that I submitted March the 7th. There was silence again, and we waited while he read. And we're up to page 11. The trooper Conley rose and said, "The people have no objection to coming back later if the court needs time to read the motion." Needs time to read the motion after the court has had the motion for 110 days? Well, Glendora minds, and this is the second time she has been to this court for nothing. I came there on March the 22nd, and it had been adjourned, and the notices had not got to me in the mail. And the court had from March the 9th to June the 21st to read a simple 16-page motion and affirmation in support. A court has a New York State responsibility to be familiar with the facts and circumstances. And also a court has to rule on a motion in 60 days. Well, this was 110. I didn't put that in this paper. Oh, that's New York State civil practice laws and rules, though, and this is the criminal practice law. Glendora was appalled the judge had not done his homework. She was equally appalled that very efficient clerk, Mrs. Coffey, had not brought the motion to the judge's attention. Page 12. And neither the clerk nor the judge asked Glendora if she minded coming back again. Well, she does. Gasoline is over $3 a gallon since New York State does nothing to protect its citizens from the gouging by the oil companies, nor from its own greedy taxes on gasoline. Additionally, it means Glendora has to find another driver. Additionally, it means another 5 hours time for Glendora and 3 for her driver. She spent 4 hours, March the 16th, and 5 hours, June the 27th, plus 1/2 hour on the Taconic with Andrews, March the 1st. And it means another dinner check added to the first $25 and the second $14. So the troopers may not mind, and the court may not mind, because they're always colluding. They're always in cahoots. They are there anyway, but Glendora minds. Page 13, Ada. There was much sotto voce as to when to adjourn. Somebody said, no, you can't do it then, it's DA night, District Attorney night. August was mentioned, and many dates in July were mentioned, and finally Clerk Coffey asked the pair at the plaintiff table if July the 6th was okay. Glendora was not asked if July the 6th was all right by her, and the clerk said to Glendora, July the 6th, I will send you a notice in the mail. And Glendora asked as to what time July 6th, and the clerk says 7 o'clock. Well, I was there at 7 o'clock on June the 22nd, and never appeared, or never was heard, I should say, until 8:05 p.m., an hour and 5 minutes later. And the clerk did not say, or as soon after as defendant can be heard. Now this might, after appearing promptly at 7 p.m., we waited 1 hour and 5 minutes to be heard. It's as bad as a doctor's office. The only thing is you don't have old magazines on the coffee table to read. There was silence, and nobody said anything, and nobody read, and nobody said adjourned. There was no gavel, and it appeared to be over. You had to guess at it. So Glendora gathered her papers and waited a moment, and nobody said anything. And it was autistic, and so Glendora said, thank you, court, and good night, Mrs. Coffey. And Glendora joined her partner, and as we exited the door, the 4 troopers were clustered. They're like bugs. The 4 troopers were clustered in the corner. And cheerfully Glendora says, gentlemen, good night. It was 8:25 p.m. and we were before the bench 8:05 p.m. to 8:25 p.m. And this is Theta. There were no other defendants present. They should have seen this procedure. They saved me to the last. They saved me until all the other victims had been ripped off, paid their money, and left. Parked next to us, our vehicle, were 4 New York State trooper cars, and one of them was a sports car. Yeah, it was painted navy blue with New York State Police on it, and it was a sports car. And it was pretty snazzy. And we headed home, and we did not go back to the diner. Christian partner asked Glendora why she did not have a lawyer. Crazy. A lawyer? A lawyer is an officer of the court. A lawyer is always going to collude with a bench. You are the last person on his list to look out for. A lawyer? In no time at all, this whole thing would have been sold down the drain, and Glendora would have been standing there paying out money. For purposes of appeal, Glendora takes exception to everything that happened in this court the night of June the 22nd, 2006, Anno Domini, Thursday, to wit. When the defendant left, the plaintiff and the accessory should have left. The plaintiff and the 4 troopers should have left at the same time that we left. They should not have lingered with the judge and the clerk to collude. All bodies should have left, and the door should have been locked, and the judge and the clerk left alone. Motion to dismiss on grounds of common law, no corpus delicti injured body, was in the hands of this court by March the 8th. 110 days circa to June the 22nd is unambiguously ample time for the court to have read the motion in its entirety. To be fully familiar with the facts and circumstances. That is the minimum that a court has to be. Fully aware, fully familiar with the facts and circumstances. The clerk was deficient in not bringing the motion to the judge's attention. 110 days, March the 8th to June the 22nd, is a heinous delay enough. And then to add another 2 weeks to it to July 6th is disgusting. Copper. Dismissal should have been granted instantly on the basis of the violation of Glendora's speedy trial rights. 70 days is the limit, and over 110 days had passed. Plaintiff's failure to state statutory authority with his opposition was insufficiency not to grant defendant's motions. Lambda, Glendora's motion to dismiss on grounds most favored plaintiff did not answer her interrogatories should have been granted instantly. On the grounds it was right, and 2, on the grounds that the plaintiff could not state any statutory authority as to his objection not to respond. All 3 of plaintiff's objections were conclusory. Moot. Conley made no appearance. He should have stated to the court his appearance, name, affiliation, and relation to Glendora's plaintiff. The 5th Amendment mandates that Glendora is to be faced by her accuser, not by a substitute, not by a suffragan. Glendora asked what Conley's role was. She did not get an answer. There was a mumble that DAs allowed state police to prosecute their own cases. That's fine, but that isn't what I asked. Who is Conley and what is his role in this court? We are up to page 18. Again, as the same, no statutory authority was proffered. Glendora takes exception to the lingering in court with no official status of Conley and the other two troopers. This was unnecessary taxpayer waste. No! The court was not prepared, the plaintiff was not prepared. This wastes scant judicial resources and defendants' resources. The entire case is a scam, an artificial swindle to augment the state revenue to spend fighting windmills. The state of New York is always fighting windmills. Don Quixote. Why were all the other cases from the rail and Glendora's from the table? Why did Andrews know it would be from the table and not the rail? And for purposes of appeal, Glendora takes exception to everything that happened in the West Teutonic Town Court, June the 22nd at 2006. And 86ers relieved, and now we go up to Jai, which is Jot Thoughts. Realizing their incompetence, Andrews, Conley, judge and the clerk, the two trooper lingerers, quickly dispersed. A little 78-year-old lady stood atop the pile of slain bodies. Glendora watched the proceedings from the front row. She could not hear all the words. This violates the Sixth Amendment. Trials have to be public, and if the public cannot hear, then the proceeding is not public. Glendora has observed many court assembly lines such as this at Taconic, June the 27th, 7 p. to 8:05 p. Citizen protest in vain, predetermined verdict always, guilty, a fine, exorbitant state surcharge like $25 for no front license plates and $55 state surcharge, $80. Can you pay tonight? Do you need time to pay? No checks, cash only. This is a RICO, a racketeer influence crime organization. In 2 hours last summer, Glendora monitored the Harrison Town Court take in $6,000. Now I say this is happening. I allege that this is happening in every court in the state of New York, and that's a lot of courts. How many municipalities are there in the state of New York? It is a RICO, Title 18, the United States Criminal Code, Section 1964, et sequitur. New York State is acting as an enterprise. Their motive is money. They use extortion, and they commit tens of thousands of predicate acts a year. RICO requires only 2 predicate acts a year, but New York State commits 10,000s. God of our fathers, whose almighty hand. That's the Mormon choir. They know how to orchestrate. They know how to make musical arrangements. They know how to perform. They are brilliant. This is my joy. Rejoice about something every 15 minutes. I rejoice about that. Continue, and we're on page 21 out of 32. It is disgusting, abhorrent, and abominable. The troopers and the judge and the clerk are all acting in concert to rip off as many naive victims as they can, and for as much as they can, and every one of them capitulates, until they got up to the little 78-year-old lady. It is such an abuse of God-given life. Make an honest living. The food, the clothing, the education that you buy your kids is bought with tainted money. And let me point out to you, the summonses that we are handed are illegal. The print does not obey legal size print standard. Every one of these summonses really, actually, legally is a nullity. Pi. Motion to recuse. Glendora moves at this court as to recusal of Judge William H. Young on the grounds of unpreparedness and ineptitude. For reasons stated herein in these 30 pages, Judge Young must recuse. By the New York State Constitution, Glendora is guaranteed judicial competence. That's in the New York State Constitution. This is also a right by New York State criminal actions law, criminal practice law, and certainly by Article 2 of the New York State Civil Practice Laws and Rules. Why can Andrews have Conley at his table and Glendora cannot have her Christian partner at her table? Statutory authority is demanded. Roe. On March the 16th, when Clerk Coffey told Glendora in court that she did not have to come tonight, it was postponed to June 22nd. Glendora asked, well, can we sit and watch? And Mrs. Coffey declined, saying that they had a busy session tonight. Well, by Article 2, the courts are open to the public. These are, after all, the people's courts. They are not the insider's courts. They are not the insider trooper, judge, clerk. They belong to the people. Glendora takes exception to what Mrs. Coffey said on the night of March the 16th. Why did they have leave Glendora until last? They should quietly dismiss the case. They should not make an issue of these matters. The more of an issue they make, the more it will be reported on TV to you, the more it will be reported on the internet. Page 24. And the more people they will have coming to the court and saying, I'm protected by the common law. Produce an injured body. Produce a corpus delicti. It was a Herculean victory for the good side, June the 22nd at 8:25 p.m. It was hot in the minuscule courtroom. You know, it's really a shack. It really is a shack. With 40 people in it, Glendora got a heat rash. She compared it mentally to the festooned draperies of the Manhattan federal courts, the great plush carpets of the Manhattan federal courts with United States seal, yeah, steel is right, seal implanted in the carpets, and with the mahogany woodwork, mahogany bench, mahogany gallery benches, money. I believe it was $500 million to build the federal court, second federal court in Manhattan at 500 Pearl Street, kitty corner from the first federal court, which was built by FDR and the WPA. Glendora is an old court monitor, an old court judge monitor for the Fund for Modern Courts, a court reform group in Manhattan. Taconic was judicially proper, having the judge's name on the bench. When you go into a court, I forgot to look at the flag. You know, if that flag has a yellow fringe around it, that's an admiralty court. And an admiralty court has jurisdiction over only crimes committed on the high sea. And it's got to be a plain flag with no fringe on it. And I forgot to look at the flag. Taconic was judicially proper, having the judge's name on the bench. But no microphones and no audibility is a serious lack. Page 25. A lawyer would have self-surrendered to the judge, the clerk, and the troopers. Instantly. Glendora enjoyed standing up for what is right and for Americanism. I'd rather than home in bed and sleep. The burden of proof for all these motions and for statutory authority now lie in their entirety on Andrews, the plaintiff. He should not have been released June the 22nd. He had plenty of time to prepare his defenses, 110 days. The police and the court conspire together to run this RICO racket. Please read Glendora's interrogatories to Trooper Andrews, to which he did not respond. And why did he not respond? There were delicious questions in there, like, are you pressured to get a quota? Are you rewarded if you have the highest number of arrests? Nice, delicious questions like that. Why does New York State require a vehicle to be registered anyway? We've registered our vehicles for 48 years. There's never been anything wrong with any of them. Why does New York State require a vehicle to be registered? I should have said inspected. Okay, and I gave you the answer to inspected. Why do they require it to be registered? It's an invasion of privacy. Why does a vehicle have to be registered? Does all that money, these troopers burn up in gasoline, ensnaring victims, and going to court, exceed the night's intake? Obviously not. They're doing it all over the state of New York, I assume. Nobody but Glendora dressed up. People attending court showed no respect for the court. I say when you go to church, you dress up. You show respect. I say when you go to court, you dress up. But it's pretty hard to have respect for the courts these days. There were no Smokey Bear hats. Glendora was wearing a white hat with an orange sunburst flower. Voila. A peach blazer, a tie, a vest, white shoes, and white bottoms, and underwear. Glendora was exuberant. They did not extort any money from her. She is the only one who left court that night without being ripped off. In many cases, the plaintiff trooper did not appear, and those cases should have been dismissed after a second call. The defendant had a Fifth Amendment right to be faced by his accuser, but no, the RICO here in the Taconic court continued to grind, and another cop out the pool, another cop out of the pool, not another cop out, but another cop out of the pool was called in as a suffragan, and this is rankly anti-constitutional, federal and state. And I will sue them for that eventually, if things come right. And other troopers present were Majek, Lawler, Jackson, Caldwell. Deponent, quote unquote, is not spelled with an E. Or it is spelled with an E, rather. Deponent is spelled with an E, D-E-P-O-N-E-N-T, not A-N-T. This is the Taconic Diner. It is a good food. The rice pudding was delectable. Corpus delecti, rice pudding, delectable. Placemat. We are up to page 28. What is the score? Glendora has made one written motion and 2 bench motions, and now she adds number 4 motion, a written motion to recuse. Instead of the long protest to motions about checks bouncing, or about Mrs. Coffey, the clerk, said over and over and over again, all right, I'll take the check, but if your check bounces, you will be I guess she was saying, charged with whatever it is, a felony. She just should have said plainly, we don't accept checks. Many courts say that. Officer Majek won the quota game for this week. He had about 10 victims. Glendora objects to Conley's slur that Glendora's pleading is voluminous. 15 pages, handwritten, in large print, is not voluminous. What is voluminous is the many summonses that desperate Andrews wrote to meet his quota. Glendora asks this court to take judicial notice of her pristine driving record. There are no offenses on Glendora's driving record. Further, she asks this court to take judicial notice that she has never made a claim against her insurance company in 46 years. $400 a year. A racket. Another racket by the insurance industry on us people. We are the people of the state of New York, not these RICO actors. Glendora asked this court to take judicial notice of Andrew's unsafe driving. It was terrible. He pulled alongside of me, he peered into the car, his eyes were not on the road, he blocked both lanes. That is unsafe driving. Trying to find an excuse to meet a quota. He drove to endanger. Further, take judicial notice that Glendora cooperated with Andrews and cheerfully. She did not have to talk to him. She could have remained silent. I said, well, good morning. How are you on this first day of March, Ash Wednesday? Further, take judicial notice that Glendora is entitled to pro se leniency. She is not to be taken advantage of by superior knowledge. The day they have superior knowledge to a pro se, I've got to see. Further, Glendora detects elements of fraud as defined infra. Now let me just take a minute, and you take a minute, to learn what fraud is. Just a few phrases here, that fraud is an intentional perversion of the truth for the purpose of inducing another to release something of valuable to him. To surrender a legal right. False representation of a matter of fact, whether by words or by conduct, by false or misleading allegations, by the concealment of that which should have been disclosed, that which deceives one, and intended to deceive one, so that that one shall act upon it to his legal injury. That's fraud. And I see fraud all over this. Do you? Remember, that is actionable. Under Title 18, the United States Code, Section 1001. Misrepresentation, lying, cheating, trickery, material fact. And paragraph 133 is reserved, and here is the a fortiori. Therefore, wherefore, and ergo, with the greater force and all the more, it is even more certain and necessary that Glendora motions be granted in their entirety, together with any further relief just and proper. Under penalty of perjury, Glendora asseverates she has told the truth, the whole truth, and nothing but the truth. So help her God. Dated June the 26th today, 2006, County of Columbia, State of New York, and it was served about an hour ago. And it's time to rejoice. Yours in truth, in Amor Patriae, in Amor New Yorki, and this is Opus 1420. And I left out the number of hours. No, it took 14 hours. That's moderate. It took more like 16, and it cost $10.42 to print and post. At court costs 4¼ hours and $14. In preparation to go to court costs 7 hours. And the internet number is circa, let's see how close I can get, 4380-5 and 4381-6, 6th edition. And again, protection by the common law. I wish I had looked at that flag. But we have to say a prayer for these people. And on the last page, the back cover, Glendora ardently prays that all contiguous to this matter find their real success, happiness, attainment, fulfillment, greatness, applause, and appreciation, and triumph in redeeming grace. Just as I am without one plea, but that thy blood was shed for me, and that thou bidst me come to thee, O Lamb of God, I come, I come. It's summertime. This is the time of the year that Americans put aside the Rubik's Cube and face the ultimate challenge of all time, refolding a roadmap. Mommy, is it true in the Bible that we come from dust and return to dust? Mommy, certainly. Little girl, I looked under the couch and somebody's coming or going. It is becoming harder and harder for us, you and me, to support the state of New York in the custom or in the style to which it has become accustomed. These troopers and these RICO courts. The famous author was asked, what do you consider your greatest work of fiction? And he said, my income tax form. Marilyn was right about her son-in-law. He said on his 1040 he reported that half of his income was unearned. Billy says, just name me one person who has any money left over after income tax day. H&R Block. And it's income tax time, and that's the time that poor people wish they were rich so they wouldn't have to pay taxes. The IRS reported that 60 million income tax forms were filed and didn't count the number that were chiseled. And it's hard to believe that this country was founded as a protest to taxes. King George III, you are avenged. You want to know something about the IRS? That it's not a law. It was ratified by only 3 states. Okay, it's not a law. It was shoved down our throats in 1913. And you know why it was shoved down our throats in 1913? To pay for the Federal Reserve system that was shoved down our throats in 1913. Somebody had to pay for it, and who's it going to be? You! And that's the international bank. Now remember, the Federal Reserve Bank is not federal. It is a private banking corporation, and it's run by the international bankers whom I sued last month. Rothschild, Lazard Frere, Warburg Pincus, the International Monetary Fund, the World Bank, Goldman Sachs, David Rockefeller, Lehman Brothers, the Council on Foreign Relations, and the Trilateral Commission were all sued for causing you depressions, for causing you wars, such as this war in Iraq, for causing millions of Americans to lose their lives, and millions of mothers and fathers to weep the rest of their life about it. Bob and Joan went to a teenage wedding. And it was interesting. Half of the wedding presents were manufactured by Mattel. You heard about the people who were so rich they bought a boy for the dog, and about the people who were so poor and lived in such a poor neighborhood that the Good Humor Man came around in an armored truck. You know about the undertaker who signed all of his letters, eventually yours. And about the picketer who carried a sign and it said, "Time heals all wounds." And the picketer behind him carried another sign that said, "Time and a half heals them faster." This is Glendora, a cheerful look at life, and it's brought to you by Keep the Courage Flaming. You have a good, pure thought. Triumph in redeeming grace. Don't let any bad thoughts into your mind. Chase them out with good thoughts. It is God's world. This is our Father's world. Oh, let me ne'er forget that though the wrong seems oft so strong, God is the ruler yet. This is our Father's world. Why should our heart be sad? The Lord is King. Let the heavens sing. God reigns. Let the earth be glad. There's your pure thought. She actually fell asleep that way. Should we wake her up? It is the funniest thing. All 4 feet in the air. I don't know what woke her up. Kitten, let's see your face. kittycat.com. There were 4 or 5 legal papers the week of June 19th last week. David King, New York State Trooper Andrews' preparation for court. and 3 would be at court, and 4 would be the post-court memorandum, and 5 is this White Plains paper. City Court, City of White Plains, County of Westchester, State of New York, United States of America, for the internet audience. Index number small claims 2005 2520. And it's an application to the court would the court please rule on Glendora's May 6, 2006 motion, copy affixed hereto, pursuant to civil practice laws and rules, Rule 2219, it should be, not 16. A judge has 60 days to rule on a motion. Motion is affixed. A copy of this application was served on Walter A. Sarrock at Sadley, Stevens, Burke & Burke, 2230 Park Avenue, New York, New York, 10169. On June the 27th, 2006, service was by U.S. First Class Mail. Also upon defendant Sadley, who is in default, and also on defendant Cecilia Masterilli, who also is in default. Here is under penalty of perjury, Glendora, without prejudice, common law protection, Uniform Commercial Code, Article 1, Section 207, Glendora. Okay. Opus 1421, 2 hours, $3. Internet number, what is it? 43. It's not even legible. It's more like 4377. But here's what the motion was about. It was a motion to renew Glendora's motion for summary judgment in favor of Glendora on the basis of a new evidence, what Sarrock did and said on May the 3rd, 2005 in the court appearances for all purposes. The issues are that Sarrock is a defendant and he cannot defend co-defendants, Sadley, Stevens, Burke & Burke, therefore they're in default, and he cannot defend co-defendant Cecilia Masterilli, therefore she is in default. The point is that no matter how much time you give Sarrock, he's going to waste the court's time. He has no meritorious defense. That has become blatantly obvious. And there are no triable issues. And a trial is just more time and expense and waste of scant judiciary resources. And so Glendora doesn't want a trial. She wants a summary judgment in her favor. And they've had that motion almost 2 months. This is the week of June the 26th, and there are 4 legal papers this week. Here's the first one. My poor copy machine. And so they were quite right in returning it. It certainly was undeliverable in Manhattan, with the letters missing. So we will simply put it in a great big envelope and address it correctly and send it back. Again, the poor tired copy machine causes error in addressing, and so we will simply address it correctly and send it back. This is Omnibus 27. William E. Smith is a United States District Judge who double-crossed the United States. This is another that the poor copy machine couldn't handle, and so we will address it correctly. And send it back. These are all judges and clerks who violated the United States laws and double-crossed America. This is in the First Circuit, which has always been bad. But this one, you see, folks, there's nothing wrong with this. This is just plain fugitivism. Goldman Sachs doesn't want to be sued, and Henry M. Paulson Jr. does not want to be sued. There's nothing wrong with this address. And it came back with this sticker. So, that's fugitivism, and that's not going to do them any good. What was being sent in those letters was my motion for default judgment against those people. The famous author was asked, "What do you consider your best work of fiction?" And he said, "My income tax form." This is the bread that my neighbor Mary just baked last night, and it's wheat and honey, right, Mary?
Mm-hmm.
And anything else in it?
No.
Salt or?
No, oh, well, there's salt and oil.
Salt and oil. And how long do you have to bake it?
That size would take about 45 minutes.
Let me give you a frame of reference. 45?
It's about a pound.
And is it very flat when you put it in?
It's round.
And it rises. Right.
It spreads.
Here it is, folks. Have a piece. Isn't that delicious? Now that's really good bread. Delicious home-baked bread. Last night. I wish you could have some. The flavor is so good. And you know you're eating something salubrious. Quick. Hurry up. You know what that is, folks? It's sunshine. You don't know what it is, do you? It's sunshine. That's what sunshine looks like. Huh? It's gone. We got there just at the 2 seconds that we had it. A chat with Glendora on 52 TV stations, 520 municipalities, including Washington, D.C. and Albany, New York. www.chatwithglendora.com. Lead people to be perfect. Stop the cruelty to animals. And sue judges when they break the law. And stop the injustice in the courts. This is Legal Papers number 3 and 4 of the week of June the 26th. Let me correct that, please. Not 3 and 4, but 2 and 3. And it's Omnibus 27, Glendora versus Stephen G. Taman in the federal court in Idaho. Stephen G. Taman believes in breaking contracts. You give your word to somebody and you go back on it, and he believes in that. And so does Deborah Eacock. Basic morality, fundamental ethics. If you give your word, go back on it. Cecilia Masterilli, who helped Deborah do that and scared Deborah at the direction of her boss, Christine Savarino. They believe in extortion. They believe in RICO. They believe you limit and prohibit public access every way that you can. You lose the videotapes, you don't return the tapes, you make believe the tapes belong to your signers. You go out and get signers, which you don't have to do, and you do everything possible to limit and prohibit public access. Robert M. Callaghy, liar for hire, and Sadly Stevens, Burke and Burke, liar for hire. Ernest C. Torres, who believes it's okay to lose a filing fee of $250. That's all right, you know. We're a federal court in Providence, Rhode Island, and that's what we're here for. We're here to lose the filing fees of litigants. and David A. DiMarzio, his clerk, and blank McCabe and blank Flanders, and the intake clerk who lost the $250. William M. Flynn and Leonard M. A. Weiss, James D. Bennett, Thomas J. Dunleavy, Neil Galvin, Chad Hume, Thomas Isabella, Stephen Shea, John Figliosi, Ann Dawson, and the New York State Public Service Commission. Their role in life is to enjoy all of the lunches and the golf and the perks that the cable operators can give them. And don't do what you're there for, which is to protect the public and to protect public access producers from cable operators. Just take in all of the pleasantries that you can from the cable operators and abandon the public in every way you can think of. Now, Thomas McAvoy is next, and he thinks it's wonderful to violate public access rights. He did it to William Houston in Binghamton, and Houston went to court to declare his rights in a court of law, and what did he find? Of course, a court of irresponsibility, a court of sham, a court of a swindle who believes that it's better to get all the benefits that the big guys can give you and abandon the little guys. And so Mr. Houston went to the United States Court of Appeals for the Second Circuit in Manhattan, and Sandra Sotomayor, and Regina Raji and C.J. Hall thought that Thomas McAvoy was absolutely right. Do not stand up for the public access rights. Do not enforce the law. Every way you can circumvent it and rule for the big guys and let the little Americans go down the drain. Savino and Rifkin Radler are sort of the same way in the lawsuit in Nassau County, Bernath versus, well, Suffolk County and Nassau. Bernath versus Cablevision. These people are also a liar for hire. They're the analog to Callaghy and Satterley in Westchester. These people are in Long Island and Catino here somewhere. These people all believe that it's great to make a living lying for somebody who broke the law. And so their children wear shoes and go to school and eat and have fun on the tainted money that their fathers earn standing up for lawbreakers. Now again, this is Omnibus 10, Glendora versus Stephen G. Taman, and it's in the United States District Court in Idaho. Now, what's wrong with Diane Bennett and Alyssa Amato, who work for Cablevision and who also make their living doing what is wrong? They took a chat with Glendora and off of 10 p.m. where it had been for 13 years and where Glendora had a public access right to first come, first serve. And they put it down at 4 p.m. in the afternoon and cut Glendora's audience by 4/5. Isn't that a nice thing to do? Isn't that in the public interest, Diane Bennett and Alyssa Amato? And now we have all Jane Does and all John Does and all of their abettors who rob us of the blue sky together with Stephen L. Johnson and the Environmental Protection Agency. And I guess that's completely stated. They have robbed you of the blue sky. We have had rain for 7 days straight, and I guess out of the whole month we've had 24 days of rain, the whole month of June. And they fairly well ruined May. Oh, what do? Well, these jets go by and at great expense exude chemtrails, and these chemtrails are aerosols, and the aerosol is ethylene dibromide, which is a poison. It was banned by the EPA a decade ago. And so these chemtrails spread out, and they keep pumping them into the sky, and eventually they have the whole sky covered. That's why you don't see a blue sky anymore. That's why you don't see the sunshine anymore. And further, this bromide has to drop to the earth, and you have to breathe it, and your children have to breathe it. And thanks to all these wonderful people, you are breathing poison. Next defendant is Lawrence Goldman, Stephen R. Coffey, Colleen C. DePiro, Richard D. Emery, Raul Linofelder, Christine Hernandez, Thomas A. Klonik, Daniel F. Luciano, Karen M. Peters, Alan J. Pope, Terry Jane Ruderman, and Jean M. Savagno, and the New York State Commission on Judicial Conduct. What did they do wrong? Well, by the Constitution of the State of New York, folks, you are guaranteed protection against bad judges. And it's their job to do it. But they would rather take the influence and the perks and the pleasantries than do the job for you. They would rather respond to the big guys and let you hang out there. Again, this is Glendora versus Stephen G. DeMond, a lawsuit in the United States District Court in Boise, Idaho. And Chief Judge Michael Bodine of the First Circuit in Boston, what did he do? Well, he thinks it's great that two of his judges in the Providence lower court, the District Court in Providence, Federal District Court, violated the United States Code. Isn't that wonderful? Bodine thinks that's good. Yeah, that's good. Go ahead. More of you judges go out there and violate the United States Code. That's just what we need. You've been violating the Constitution for decades. Yeah, now go out and violate the statutes. And also C.J. Bodine renders meaningless our right to correct the sinking judiciary with complaints of judicial misconduct and disability in federal judges. He has rendered that meaningless. It is codified as Title 28, the United States Code, Section 371. So, he just sides up with the bad guys, and he spurns you, the good guys. Now, Mary M. Lisi and Lincoln D. Allman in Providence are the two judges who broke the United States Code, who violated the United States Code. Section 636 says clearly that no magistrate, in this case that's Allman, should touch a litigant's lawsuit without that litigant's consent in writing. Lisi is the United States District Judge. But they went ahead and did it. And they were warned of it, and they went ahead and did it. Now we have James Reynolds, who is the son of George Reynolds, whom I knew, and the brother of Jeffrey Reynolds, whom I know, and Mid-Hudson Cablevision, and Rob Johnson, and Lori Pulver, and Stuart Smith, and Mid-Hudson Media. They do not believe in obeying the public access law. They have violated New York State on about 10 counts. They are fugitives. They never read the letters from the court. They never read an order from the court. They are just plain fugitives. They're scared stiff, apparently, and they just refuse these. So not only are they defendants, but they are fugitives. We have to pray for these people. Pray for these people, James Reynolds, Stuart Smith, Lori Power, Rob Johnson, Mid-Hudson Cablevision, Mid-Hudson Media. Jennifer Oyala, in collusion with Christine Savarino, chopped a chat with Glendora in Cross River from 2 hours down to a half an hour. They violated New York State Public Service Law, Article 11, Section 229, no cable operator shall limit or prohibit public access. They violated no cable operator shall exercise editorial control over public access. They violated first come, first served. They violated that public access shall be administered on a non-discriminatory basis. Bad people, Oyala, Masterilli, and Severino. This is to Elliot Spitzer, who failed miserably to defend the New York defendants, you know, like the Cable Commission, the Public Service Commission, and the Judicial Conduct Commission. And he has an amanuensis there, amanuensis named Gardy. Henley's in charge of her and Rifkin, and they just let it go. The rot that comes out of the New York State Attorney General's office. Whatever you do, do not vote for Spitzer. Glendora has him on record as telling dozens of lies. Now how can you be a New York State Attorney General if you tell lies? There's a blank. There's one we missed. We missed the State of New York, its Court of Appeals, its Appellate Division, the First Department in Manhattan, its United States District Court, Supreme Court, because they ruled that we could not have our cameras in the courtroom. Why not? Courtrooms belong to the public. Read New York State Judiciary Law. Read New York State Judiciary Law. These are our courtrooms. We should have our cameras there, and we should have our microphones there, our audio tapes there. And we all know that judges and clerks all tamper with the record and commit dozens of crimes as to the record. And so that was all in care of Judith Kay, the Chief Judge of New York. I sent a courtesy copy to the United States District Judge, Edward J. Lodge. And then, of course, this one goes to the Clerk of the Court. And this one goes to a juvenile lawyer. I never saw such kid stuff. Yet he gets paid for it. And this Stephen G. Taman, who is a town justice, Phillipstown, County of Putnam, State of New York, he hired this hack to lie for him. Yeah, they both look so bad. Now this one is my favorite. Isn't that fun? Oh, don't you love it? Isn't that cute? I almost made it. And so to make up this 39 cents, I had to give the post office an extra penny. It's 40 cents. And this one goes to the U.S. Attorney in Idaho, the District of Idaho. And I tell you how badly the New York Attorney General lies, but as bad as they are, a U.S. attorney lies worse. Never trust a U.S. attorney. Never trust a U.S. attorney. They are rotten to the core. Now, what's this paper all about? So, what is this all about, folks? Well, there's a magistrate out there in Boise, Idaho, who violated the United States Code. Section 636 says no magistrate shall touch Glendora's lawsuit without her consent in writing. Well, he went ahead and did it and wrote a report and recommendation that the United States District Judge Lodge dismissed my case. And these people have lied from the beginning. First of all of these defendants I just read you broke the law. And then all of these cheap lawyers lie about it. And then we have a magistrate lying about it. And also breaking the United States Code. His name is William. What is his name? Williams. M.H. Williams is his name. And so I get this letter from, or this opposition from Quayne Smith and Contino, and it's a response to an apparent objections by Glendora. Well, I made it very, very clear, and I guess as this paper is going to tell you, I think this paper now will explain itself. This is a nullity for the same reason that Williams' order was a nullity. So when they do something bad like that, you let the whole United States know. And it says, you have already been told that the paper by M.H. Williams is illegal, unlawful, nescient, and violative. It has no standing in this court. Williams has violated the United States Code. This is actionable. Not only is this paper a nullity, it is an accusatory instrument. His violation of the United States Code is actionable, and this paper is a nullity, and so is yours. And this is written to Quayne Smith in Boise, Idaho. Further, you are in violation of the Federal Rules of Civil Procedure, Rule 11 in 1996, the Judicial Council of the United States made it clear that lawyers had to sign their papers. Let me show you this one. It's not even signed. Look at it, folks. No more of that stuff. Your supercilious S is a hoax, as is the rest of your lawyers' lies, and the rest of your lawyers' lives in this action, Glendora versus Taman et al. Further, nescience, you did not serve all parties, you did not serve Reynolds. And Cameron Burke, why did you send Glendora another Rule 56 equals Rule 12 memorandum? You already sent her one. And Cameron Burke doesn't know enough either to sign a paper in violation of Rule 11, Federal Rules of Civil Procedure. And what this paper says is that it's a notice to a pro se litigant by mandate of the Ninth Circuit in San Francisco that somebody is trying to dismiss the pro se litigant's case either by Rule 12, which is a terrible hodgepodge of meaninglessness that says you didn't state a cause upon which relief could be granted, that's stupid, and or Rule 56 summary judgment, and summary judgments are illegal, they are unconstitutional, they deny due process, they rob you of discovery, they rob you of jury trial. It's just a cheap, dirty cop-out for dirty, cheap judges. Okay, so Cameron Burke, why did you send that to me? And it is time that this to cease this frivolous make-believe and Gilbert and Sullivan and get down to, here's what we need, folks: the effective and efficacious administration of the business of the courts, which is justice. Have you ever heard of it? And we served all parties. We just served them now. The effective and efficacious business administration of the business of the courts comes straight from Title 28 U.S. Code 371, judicial misconduct and judicial disability. Well, folks, we made the 11:30 mail pickup. Yeah, but, you know, there wasn't room there to say a prayer for these people. Will you pray for these people for me? All these people who are ruining their lives and the lives of others in the United States. Pray for them. Pray for them that they find the real path to success and happiness and attainment and applause and appreciation and goodwill and popularity and acceptance and control and strength and accomplishment and beauty and that peace that passes all understanding. Pray that they find it. Let's sing in this hymn. Come thou almighty King, help us thy name to sing. What's next? Let's start over again. Come thou almighty King, help us thy name to sing, help us to praise, Father all glorious, o'er all victorious. Come and reign over us, on us descend. That's good. We sing that for those people. That'll fix them all up, and then they'll be really happy. Father all glorious, o'er all victorious. Folks, this is summertime, and this is when Americans put aside the Rubik's Cube and undertake the challenge of all times, the ultimate challenge, which is refolding a roadmap. Mommy, is it true that the Bible says that we come from dust and return to dust? And Mommy said, certainly. And the little girl says, well, I looked under the sofa and somebody's coming or going. It's getting harder and harder for us to support New York State in the style to which it has become accustomed. A famous author was asked, what do you consider your greatest work of fiction? And he said, my income tax form. Peter's mother-in-law said, at least he was honest on his 1040 tax form. He reported that half of his income was unearned. And when it's tax time, poor people wish they were rich so they didn't have to pay taxes. The IRS said that 60 million tax forms were filed. That doesn't count the ones that were chiseled. And name anybody who has any money left over after income tax day. H&R Block. And it's hard to believe that this country was founded as a protest against taxes. George III, you are avenged. Marilyn and Bob went to a teenage wedding, and it was interesting. Half of the wedding presents were manufactured by Mattel. Did you hear about the family that was so rich they bought a boy for the dog, whereas the family that was so poor, the good human man used to come around in an armored truck? Did you know about the undertaker who signed all of his letters, eventually yours? And the picketer who was carrying a sign that said, "Time heals all wounds, time heals all wounds." And the picketer behind him carried another sign that said, "Time and a half heals them faster." This is Glendora, a cheerful look at life. Brought to you by two cute little puppy dogs. He's so cute. This is legal paper number 4 out of 5 for the week of June the 26th, 2006, Anno Domini. And it is going to Cecilia Masterilli, Cablevision, Peekskill. Governor Pataki is coming home to Peekskill. To Walter Sarrock and Satterley Stevens Burke and Burke, Liar for Hire, the Pan Am Building in New York. Officer Lewis, who is in default. Police Department of Peekskill. Defendant Tabat Salako in Peekskill, and Defendant Jill DeCrenza, who is in default in Peekskill. And to Judge Arthur C. Duran III, City Court, Yonkers, New York. This is on a 9x12 envelope, and it says, "Dear Christine, Glendora is praying for you and for Cecilia, that you be 100% whole and happy and healthy, that you find your oneness with God, and that you have all the money and big houses and big cars and success and attainment and fulfillment, peace and joy, appreciation and applause that you want. Please stop being so mean to public access producers. By mid-July this year, you may not have any public access to be mean to. If the Senate does not, as the House did not, say nope to cope." Glendora's friend in Wappingers went to Cablevision to pick up her 40 VHS. An amicable young man, a youth there, told him her tapes were sent to Peekskill. Now why did you do that? Why did you do a dumb thing like that? Glendora left a message on Cecilia's recorder in Peekskill. That her friend Susan in Peekskill would pick up Glendora's tapes, but Cecilia has to go autistic, and Glendora never hears from Cecilia. Why can't you be nice and civilized and return calls? Glendora calls her Reverend in Hopewell to find out who God is and what God is, and he ends up telling me that Cecilia called him and told him one of Glendora's tapes was broken. Now, my minister could not remember the number of the tape, and why do you bother him? He is a man of God with many people of many exigencies to help. You should call Glendora. She owns the tape, and why do you do mean things like that? Glendora demands you send her the damaged tape postmarked no later than July the 7th, 2006. Glendora sent Cecilia 3 programs last week. Be nice for a while. You will not get all those joys that Glendora mentioned. Super, if you continue to be so nasty. You make us get community signage, yet you do not administer public access. Community by community. You should have a community public access administrator in each community. You should have one in Yonkers, you should have one in Wappingers, you should have one in Yorktown, you should have one in New Rochelle, and you should have one in Ossining, Inter Alia. Time Warner and Comcast administer public access so much more efficaciously and amicably. Yours, Glendora. And I sent the copies to the people you know because I just read you the envelopes. Glendora on 52 TV stations in 520 municipalities, including Washington, D.C. and Albany, New York. www.achatwithglendora.com. Lead people to be perfect, stop the cruelty to animals, stop injustice in the courts, and sue judges. And the internet number is 4353, edition 8. You call me. I'm the owner of the tape and the program. Devotions this morning is Colossians 3:12. It's terrific, folks. Keep it in your heart. I like this. God, I don't ask you for anything. You got enough to do. Make gratitude a habit. Make gratitude to God a habit. Say thank you instead of please. Say more thank yous than you do please. Glendora, to you, the peace of God rule in your hearts. Sing with gratitude to the Lord. Giving thanks to God, the Father. And here goes a cat by. Now this cat is a judge. Okay, these are the legal papers over here. This is a big, big legal paper that's being worked on now. Of course, Hummel, who betrayed everything good. And so she is a good judge.com. She loves to sleep on legal papers. And it has rained for 3 hours straight, and for 3 days straight. But, you know, rain is an amazing thing. You know, just stop and think of it. It comes down, it stays, and then it goes up again, and then it comes down again. And it comes down in little drops. Rain is really amazing. This is a cut glass vase that .com is drinking out of. Oh, look at that face. Oh, what a great face. .com can't go out and play. And how she loves to run. Oh, how she loves to run from the elm tree to the door. Here is laughter from New Haven, Connecticut.
So I'll tell you today's joke. What's today's joke? Computers are in the Bible. Eve said to Adam, "Do you want an apple too?" That was a good one. We have apple computers here. That was funny. Okay, thank you, Glendora. Thank you, Daisha. Bye. Have a nice evening. You too. Thank you. Bye. Bye.
Last legal paper of the week. And it's the last hours of the week. So we're not going to end up with any free time. And here's who started it. Defendant Appellee Diane Bennett, Cablevision, Woodbury. And her accomplice. Defendant Appellee Alyssa Amato, Cablevision, Woodbury. Cost $2.87 to mail this. A Chat with Glendora on 52 TV stations, 520 municipalities, including Albany, New York, and Washington, D.C. www.achatwithglendora.com. Box 124, Ghent, New York, 914-949-9495. Our platform. Lead people to be perfect, stop the cruelty to animals, stop the injustice in the courts, and sue judges when they break the law. Really the one who started it all, Charles F. Dolan, chairman of Cablevision. You pay yourself $9 million and you pay your son $9 million. This was for 2005. And then you deprive Glendora of the $33,000 default judgment, rightfully hers. Charles Dolan's son James and Cablevision Systems Corporation, Bethpage. You give yourself $9 million last year and deprive Glendora of her $23,000 default judgment that she deserves. And then comes the judge, the evil judge, Christian F. Hummel. Rensselaer County surrogate judge. What's he doing in Columbia County? And he's the most evil. And you will hear about him and what he did. Pages and pages. This paper is 100 pages. It took 26 hours to write it. Print it. Do the envelopes. Collate it. Staple it. Label each one. And here's the liar for hire. Sadly, Stevens, Burke and Walter A. Sarok. They may be at the moment an unpaid liar for hire because they made such a mess of things. And lied worse than before, and cheated worse than before, and stolen worse than before. And it cost $55.64 to print it and to post it. This is going to the clerk of the court, the Supreme Court, the County of Columbia, the den where all this evil started. Urgent, please file immediately. And to the boss of the bad judge, Christian Hummel's boss, George B. Cerisier, Jr., 3rd Department, New York State Court Administration. And to Judith K. This is a constitutional issue. We're not going to stop at the 3rd Department, the Appellate Division. We are going straight to New York State Court of Appeals, the highest court in the state, the Judith K. Court. And to the chairman of the New York State Commission on Judicial Conduct, who is charged by the Constitution of the State of New York to protect you from bad judges. And Christian F. Hummel is a bad judge. Now, do you think we will make the 11:15 pickup, postal pickup? Here's the paper, folks. It started on June 28th. It's to the Supreme Court, County of Columbia, State of New York, United States of America. The index number is thusly, and it costs $315. And it's Glendora's reply affirmation for her motion for relief from Hummel's order, reconsideration, and pursuant to New York's State analog to Federal Rules of Civil Procedure, Rule 60B, that Hummel vacate and reverse his May 17, 06 order, that he grant Glendora her just default judgment of $23,000, grant $10,000 penalty stipulation, and grant 26 make goods as specified, grant $10,000 in sanctions to this court as moved, a declaratory judgment as to Bennett and Amato are conducting a lottery, or honor Glendora's demand for a jury trial, or return her $315, both with 9% statutory interest since December 1st, 2005, together with any further relief that is just and proper. Well, that motion I read to you, it was very long. I think it was 70 pages. And Sarok, the liar for hire, gets out an imbecile paper that's inadequate, inept, and is full of lies. There's at least 60 lies in it. And so I am replying to that Sarok paper of 6 pages. But before I do reply to it, I go through every phrase and every sentence and every paragraph and every page of the bizarre and unjust and abhorrent order of Christian F. Hummel. And Glendora says to Christian F. Hummel, you produce a statute of limitations on prosecuting a default judgment. Bring to this court any statutory authority for denying a motion for default judgment of indisputable default, January the 16th, 06 to February the 17th, 06. 30 days late answering the complaint. Invoke something other than mere dictum or improper influence. That was alpha, this is beta. Justify that summary judgment against a pro se civil rights case is proper. Pro se civil rights cases must not be summarily dismissed. Justify that the court was proper in robbing plaintiff Glendora of a hearing, of robbing her of discovery, of robbing her of the jury trial that she demanded, of robbing her of due process, law, of her day in court, of her 5th, 14th, and $23,000. You justify that, Christian Hummel. The issue is not how Cablevision allocates programming time slots, as Hummel says. The issue is Cablevision is not a defendant. Bennett and Amato are the defendants. No matter how Bennett and Amato change Glendora's time slot, it is illegal until Glendora consents. The issue is first come, first served. The issue is violation of 16 New York Code Rules and Regulations, 895.4. No cable operator shall exercise editorial control over public access, and no cable operator shall administer public access on a discriminatory basis. And Glendora told Hummel that 10 times. Now, what happened, as you remember, Bennett and Amato at Cablevision in Nassau moved Glendora's time slot from 10 p.m. Fridays down to 4 p.m. Fridays and cut her audience by 4/5. There used to be 430,000 subscribers in the Nassau system, but with satellite that has probably been reduced, and Cablevision is so devious and so dishonest and always has been. Well, they do crooked things, that's why, and they're dishonest because they have to cover them up. Will not tell you how many subscribers they have, so we're estimating. Now we are on page 3, and I think it's it's 12:15, and we're going to rejoice. That song is a song of rejoice, the rejoicing for the harvest. I'm going to rejoice for the 4th of July, for the Declaration of Independence, and for summertime. And also I have the happy book here to rejoice. I have a word that I can't understand. The word is abstract, and the word is so abstract I can't understand it. I can't apply it to anything. Can you? Abstract. Any application to a particular object, apart from any application to a particular object. Well, we have noise from the sky, we have noise from the land. There must be some noise going up the Hudson River. Expressing a quality apart from any object. That is, honestly and unjustness. Well, I understand honestly and unjustness. It certainly applies to Hummel's bad case here. And abstract comprises or concentrates in itself the essential qualities of a large thing. Yeah, you make an abstract of a large thing, that we can understand. We are up to page 3.